By the end of this lesson, you will be able to apply HIPAA rules to a medical scenario and complete a release of record form. Let's start with defining two basic terms, privacy and confidentiality. So keeping your privacy or maintaining it means that you are free from unwanted attention. That's the official definition. So think about it. What does it mean when someone invades your privacy? If we look at that definition, basically it's anytime someone is giving you attention that you have not asked for or you don't want. Now, many of the activities we do in healthcare are private in nature. Think of a physical exam. Being undressed in front of another person is a very private act. So we need to always be respectful of a client's privacy and protect them from exposures. An invasion of privacy would be considered an intentional tort and therefore could result in a civil lawsuit. Now, confidentiality is a legal right, as we discovered when we looked at the Patient Bill of Rights. State and federal laws protect a patient from breaches of confidentiality. In other words, from breaking or exposing their confidential information. So, in other words, they are there to protect a client's private information from being shared with people who have no business having it. This includes their medical information, their insurance information, and their financial information. The use of electronic transmissions lowers administrative costs, but it makes it harder to keep health information private. When we started using electronic health records, the need arose for laws that regulated the electronic transmission of patient information. Congress passed the Health Insurance Portability and Accountability Act, also known as HIPAA. The initial goals of HIPAA were to make the transmission of electronic health information easier and more consistent, as well as to encourage more healthcare facilities to use electronic records. As part of this, a universal coding system was put into place so that everybody was using the same codes across the nation for various diseases, procedures, equipment, etc. As more facilities started using electronic health records, the need to guarantee security and privacy for each patient became more evident. So, extensive privacy rules have been added to the initial law in recent years. The HIPAA privacy rules set national standards that protect healthcare records and other protected health information. We refer to protective health information as PHI. So, covered facilities must ensure that any business associated with healthcare records must keep PHI, protected health information, private. Within the privacy rules, patients have rights, and these rights include that they have the right to examine their health information. They can look at their health information, basically. They have the right to obtain a copy of their healthcare records, and they may request corrections be made to healthcare records if they are incorrect. The HIPAA privacy rule also lists reasons that PHI can be released without having to obtain consent from the patient. These times when we can release records without consent include to the individual. So if the patient wants a copy of their healthcare record, they may have it without completing an authorization form. treatment, payment, and healthcare operations. So we can share records to coordinate treatment with other healthcare professionals, such as family doctors sharing the health record with the surgeon. We can also do this for information for insurance companies so that they can reimburse the office. And within the healthcare facility, we have other departments, such as legal and finance, who may have access to the records to improve the quality of care that we are providing. Also, we have use and disclosures with opportunity to agree or object. Okay. In other words, a patient can just give just-in-time permission for disclosure of information. This occurs when a patient has another family member with them in the office, say for example, and we ask the patient if it's all right if that person remains in the room. The patient can say yes or no. If they say yes, they've given permission to disclose information to the other person. If they say no, we need to ask the other person to leave the room before we discuss any topics with the patient. Another time we don't need an authorization form is what we call incidental use and disclosure. So we take every precaution to avoid others overhearing our conversations about our patients. However, if, for example, we're talking on the phone with a client in a private area and someone suddenly walks into the room, this privacy rule protects us. It happened to be incidental when the person overheard a conversation about a patient's information. It was not done purposely or intentional, and we do not have to have that person fill out an authorization form because someone walked into the room while we were talking to them. Another time we don't need an authorization form is when times of public interest and benefit activities. Example, in Pennsylvania, when a person is killed in a motor vehicle accident, an investigation must be performed. The coroner has the right to the person's personal health information to complete the investigation, and we do not have to get a release signed to do that. And in fact, we can't because the person is dead. The last time is what we call a limited data set. And this is when we take a record and we remove all the patient identification information from it so that the records can be used for something like research. So in other words, we take out anything that would associate this data with a particular patient. So the key information here is to understand that there are times when protected health information can be released without a patient's consent. However, here's my caution. If you're ever unsure if it can be released, verify that you can do so. Ask your office manager, ask a supervisor, ask someone in charge if you can release the information before you do so, and you will be safe. So in the privacy rules, we mentioned disclosure authorization forms. And these are documents that are kept on the patient's chart that state who the provider can share PHI with. You may have filled one of these out when you went to your physician's office. If a person calls requesting information on a current patient, you should first ask the caller's name. If the caller is not indicated on the form on the chart that states that we can disclose information to them, we cannot release the patient's information, and we cannot acknowledge that the person is even a patient in the facility. In some facilities, the patient comes up or the patient is given a code word or a number that they can then distribute to family members that will allow them to get information. This sometimes happens in like outpatient surgery when a patient comes in and someone has to come in with them. The patient is issued a card that has a number on it that they can then give to the person who was with them. And if the person with them would like information on how they're doing, where they're at in the OR, etc., they can call in and give that number, and then they will be given information about the patient. If a client's records need to be transferred to another provider, it can be done by a patient's request or by the provider's request. Either way, a records release form must be completed. So this is a form that allows us to release the records to another facility. Now, no records, including lab results, pictures, videos, etc., can be released without one of these forms being completed. Now, parts of the patient record are held at a higher level of confidentiality than others. This includes things like psychotherapy notes, drug and alcohol substance abuse information, and information related to HIV. So that is actually held at a higher level of confidentiality than the remainder of the record. Therefore, you're going to see release forms that include a separate area where patients must give additional permission for this information to be released. If they do not, this information must be separated from the record before it is transferred to another facility. So you have an obligation both morally and legally to protect a patient's privacy. This includes their physical privacy as well as their health information. HIPAA regulations were put into place to protect against breaches of confidentiality when working with health information. As a healthcare provider, you must know what health protected information can be transmitted and released and what cannot be, and the process that is required for the release of PHI.